All right, hello. Thank you all for joining me. My name is Joshua Bengal. I am the Director of Government Relations and in-house lawyer at the Medical Society of New Jersey. Welcome to our new lecture series. This is lecture number 6 concerning telemedicine, including practicing telemedicine across state lines, what you need to know. I have to say, as I was preparing this lecture, I was having flashbacks to law school. You really could make a constitutional law examination question be just one sentence. Prepare a talk for physicians on the current state of telemedicine law in the United States, covering applicable legal cases that are now pending. So I hope you will all enjoy your journey with me. If you didn't go to law school, I know one of the participants today who isn't me went to law school or is currently in law school. But if you did not attend law school, this is your chance to have Con Law 1, hopefully in a way that is valuable to you as practicing physicians. So why don't we get started? I should also add, if you have questions or if something I say just doesn't make sense or doesn't ring true, please jump in. We are a small group tonight, a small enough group that is a completely valid way of proceeding through the evening. I should also say that because this is part of our lecture series, MS&J has really sought to essentially create a compendium of lectures that serve as some of the best education that physicians in the state can get. We will be posting this lecture to YouTube and to our website, and we hope that you will review it afterward. If you have questions later, if you think that there's someone who might benefit from it, please feel free to share the link. Okay. Now I will get started. Telemedicine, where we're going to end up on our telemedicine discussion at the end of this talk is the current case pending in the district court for the District of New Jersey, a federal lawsuit entitled McDonald versus Sabando. But where we're going to start our journey is all the way back in time. And I decided to arrange this chronologically because I think that gives it sort of a more intriguing flow and will give you a sense of how our current state has its genesis and its basis in the Constitution and in case law that was developed almost 250 years ago. So let's get started. I should also say, I'm sorry, before I start on our constitutional journey, I want, if there is one thing that you remember for practical purposes after this talk, it is that in order to practice telemedicine in the United States and in one of the states within the United States, you need to be licensed in that state. And when I say practice telemedicine, I actually mean two things. The first is if you are currently located in a state where you are providing telemedicine services, you need to be licensed in that state. The second is if your patient is currently licensed in any state, you need to be licensed in that state. And that is because essentially all states, not essentially, all states across the United States require licensure of the physician if the physician or the patient is in that state. I see Dr. Mazzola has a question.
So do you mean your patient lives in the state or is licensed? You mean the patient lives?
No, I actually mean if your patient is currently located when you are providing the service. So if you have a patient who lives in New Jersey, let's say you have a patient who lives in New York, right by the state line and drives into New Jersey, and you're a licensed practitioner in New Jersey, you can treat that patient so long as you're adhering to the standard of care and establishing a proper doctor-patient relationship. But if the patient then goes back over the state line and is at their home in Rockland County, New York, let's say, then you would need to be licensed in New York. So just remember that as we sort of go through our journey, and we can talk more about that later. Okay, so going back to the founding of the country and the ratification and effectiveness of the Constitution. The Constitution was ratified in 1788 and became effective in 1789. One of the principal and what became a very important clause within Article 1 of the Constitution is what's known as the Commerce Clause. And this is all going to become relevant as we continue on this journey. The Commerce Clause states, the relevant portion is actually very simple. It states that Congress shall have the power to regulate commerce among the several states. There are other parts, but they're not relevant to our discussion here. So Congress shall have the power to regulate commerce among the several states. Ratified at the same time as the Constitution were the first 10 amendments. They actually changed the Constitution. They amended the Constitution, and they are known commonly as the Bill of Rights. They were part of sort of a negotiated settlement that allowed the Constitution to be ratified by the necessary number of states. The 10th Amendment to the Constitution, which was again ratified at the same time that the initial Constitution was, has its own provision that essentially reserves powers to the states if they are not delegated in the Constitution to the federal government. It states explicitly, powers not delegated to the United States are reserved to the states themselves. And what this means, this sort of combination of the Commerce Clause and the Reserved Powers Clause in the 10th Amendment, is that if a state tries to, or I should say, when the federal government tries to regulate interstate commerce, it has the authority to do that. But when the state wants to do something that is a reserved power, and a classic reserved power is professional licensing, it shall have the power to do that. So you can see we're already establishing this sort of tension that is going to become relevant in McDonald versus Sibando, which was filed in 2024, between the federal government's ability to regulate commerce in between state or among the states, and the individual states' ability to do whatever it is that they have reserved to themselves. And that includes professional licensing. It also includes things like the police power to enforce state laws, the ability to allow municipalities to be formed. Like, municipalities only exist because the state government says that they can exist. So you see this tension building. Let's fast forward from the late 1780s to the early to mid 1800s. In 1824, the Supreme Court created the very beginning of a concept known as the Dormant Commerce Clause. And this concept, which was pretty well established through Supreme Court jurisprudence by the 1870s, essentially is like a corollary to the Commerce Clause in the Constitution. So the Commerce Clause in the Constitution says that the federal government shall have the power to regulate commerce among the several states. The Dormant Commerce Clause states that when an individual state tries to regulate commerce that can interfere with commerce in other states, that shall be prohibited. And it's the idea that if the federal government can do it, it's implicit that the states can't do it. So that's the Dormant Commerce Clause that's created initially, or the very beginnings of it are created in 1824 by Chief Justice John Marshall. And the concept is well established by the 1870s. Now let's fast forward, 150 years or so to 2017, and let's home in on New Jersey. In 2017 in New Jersey, the state legislature passed and the governor signed a law known commonly as the telemedicine law. And it essentially laid out the boundaries for it established that telemedicine could legally be practiced. The truth is, 2016 and earlier, it was kind of an open question whether telemedicine could be practiced in the state of New Jersey. But starting in 2017 and after, it was clear that it could be practiced. It was legal to practice so long as it conformed to certain requirements. And those requirements included totally logical things like you have to adhere to the standard of care. You have to be a licensee in New Jersey in order to practice telemedicine in New Jersey. You have to establish a legitimate doctor-patient relationship. You have to keep medical records. Essentially, all of the reasonable things that you're really required by the standard of care to do when you're treating someone in person, you have to do those via telemedicine as well. But here's the thing. The law was passed in 2017. I was actually a government lawyer at the time. I was tasked with crafting some of the regulations that implemented the law. And I can say that within the state government, we felt like we were doing a lot of work for almost no purpose because no one was practicing telemedicine. There was no reason to do it. There was no history of doing it. Patients weren't used to it. Doctors didn't have the systems that they needed to start treating through telemedicine. And the truth was there was no telemedicine reimbursement requirement. Telemedicine arguably was required to be reimbursed by insurers, but there was no requirement that the level of reimbursement be anywhere near parity with in-person care. And then you can probably all guess what happened 3 years after the telemedicine law was signed. Dr. Blumenthal, what happened in 2020? COVID, the pandemic in March of 2020 essentially shut down just about, not everything, but just about everything. Actually, I'm probably talking to a group of people who didn't get shut down. You probably went into overdrive when the COVID pandemic began. But the process of going to your doctor, if you did not have COVID, I'm sure you all remember, no one was going to the doctor unless it was an absolute emergency or if you had COVID-19. Actually, even then, you were probably pretty quickly were instructed not to go to the doctor because the goal was not to infect others. So telemedicine all of a sudden became incredibly common, incredibly desired by patients, incredibly helpful to keeping patients as healthy as possible at a time when they weren't able to get to the doctor's office in the traditional sense. Again, I was still working in state government at the time, and it was a scary and upsetting and also exhilarating time. As someone who worked in professional regulation for up to that point, essentially my whole career, the task all of a sudden switched from making better regulations, which had really been the task from the 1890s on, when professional regulation at the state level of medicine really began. The task within a week or two essentially became unwind all professional regulation that you can possibly safely unwind. Really probably a once in a lifetime experience for a government lawyer in this context. But one of the things that we unwound was the state licensure requirement. And we were able to do so under the authority of some executive orders that were signed by Governor Murphy in March of 2020. And what it allowed was physicians to practice telemedicine across state lines. And it also worked quite well because all other states in the United States also waived their own licensing requirements. And so you had essentially a free flow of telemedicine being practiced across state lines throughout the country. Those waivers were retracted in all states. I don't think there's a single state that still has their telemedicine jurisdictional waivers still in place. The waiver in New Jersey was retracted in 2022. And what that meant was that you all of a sudden had people, and this is where we'll get into the lawsuit, McDonald versus Sibando, You had people who became used to seeing their physicians in other states via telemedicine, who no longer could. And that's exactly what happened to the plaintiffs in this matter. So I'll focus, there are actually multiple cases, but I'm going to focus on McDonald versus Sibando, because it's the one that concerns New Jersey, and I'll focus on the story of McDonald, the plaintiff. So McDonald is actually the name of I believe, a minor plaintiff who had cancer at a very young age. I want to say age 2 or 3, and was successfully treated by a physician at Massachusetts General Hospital. And thank goodness the patient recovered and has been in remission for years now, but the patient is required to go for regular cancer screenings annually, and will likely really need to do that for the rest of their life. And the parents of this minor patient really developed a fantastic working relationship with the physician at Mass General, and became used to meeting with that physician via telemedicine during the pandemic. When the waivers that allowed that cross-border telemedicine to occur were retracted, the plaintiff eventually initiated this lawsuit, really challenging the sort of fundamental premise of this reserved power, that states are able to regulate things like professional practice and professional licensing, and control the professional practice that happens within their borders. Now, the plaintiffs make a number of arguments in their case, ones that cover things like the First Amendment. They essentially say that a physician has a First Amendment right to treat patients who are not located in their state. They make a due process argument, arguing that they have been deprived of due process because they can't seek treatment from the physician whom they want. They make an argument under the Privileges and Immunities Clause of the Constitution, arguing that the state is denying the privileges and immunities, but mostly the privileges, that it should be granting to all physicians, that it's only granting those privileges to New Jersey physicians. And then, of course, the lawsuit makes the argument that I sort of alluded to earlier, the Commerce Clause argument. And that is that the state is violating the dormant Commerce Clause, that the state doesn't have the authority to interfere with interstate commerce among the several states. Those 3 bases for the lawsuit that I mentioned, First Amendment, due process, and privileges and immunities, those to me don't really pass the smell test quite as much as the Commerce Clause argument does. And I was happy to see, when I did some research and I read what some legal experts, real legal experts, not like me playing a legal expert on TV, but real legal experts, they seem to agree that it's the Commerce Clause argument that is the most compelling and probably the most concerning for the defendants in this case. But yeah, the case is in the early stages now. Federal litigation is extremely slow. It will be years, most likely, before the case comes to any real resolution. So there's a lot more that we need to sort of just wait and watch about the case. But if there is going to be movement in the plaintiff's direction on this case, I suspect that it will be based on that dormant Commerce Clause argument, that a state can't legitimately interfere with interstate commerce even though it arguably has a reserved power in the ability to issue professional licenses. Now, I do want to note that there are a couple of ways, at least one way that I can think of, that the problem could be ameliorated, and it doesn't require litigation. and that is the path of interstate licensure compacts. You've probably all heard at some point about interstate licensure compacts, largely because New Jersey has actually entered into the interstate physician licensure compact. Now, there are generally two main models of interstate licensure compacts for professionals in the United States. There don't have to be. There's really an infinite number of ways that you could structure these interstate licensure compacts, but most of the compacts that I'm aware of fall into two main models. The first one I'll mention is the one that the nurses actually pursued. And what it essentially is the best way I can describe it is if you get an interstate license, we'll create this new concept called the interstate license. If you get an interstate license from a state that is in the licensure compact, you can go anywhere in any other state that's part of the compact and practice there. So, and this is the case in the United States with nurses. A nurse can get a license in New Jersey and then go to another state that's part of the nurse licensure compact. Let's say, I don't know, Ohio. I don't know if they are, but I think they may be. The nurse can go work in Ohio. They can get a job in Ohio. In many cases, they don't even have to actually register with Ohio authorities. They can just practice under the authority of their New Jersey interstate license. That is not how the physician compact license is set up. The physician compact license is much more of an accelerated licensure process. So if you hold, and New Jersey is actually, like I said, part of the physician interstate licensure compact, but it doesn't mean that physicians licensed in New Jersey can be considered licensed in other compact states. What it does mean is that physicians will now have an accelerated process for obtaining a license in those other compact states. I think it is sort of, well, clearly the physician who works at Mass General did not think that this was a sufficient path forward, which is why they, along with McDonald, decided to file the case against Otto Sibando. I should have explained that. Otto Sibando is the current president of the Board of Medical Examiners in New Jersey.
Nice guy.
Yeah, I'm sorry?
Nice guy.
Yeah, he is a nice guy. I was actually pleased to see that they didn't sue him in his personal capacity, which is kind of just like, sticking the knife in and then turning it a little bit. Suing him in his professional or in his government agent capacity seemed like the, what's the word? Just the honorable way to go. But I think this is a relevant sort of piece of background information that everyone should be aware of, these interstate licensure compacts. But just note that it doesn't really solve the problem, especially because the physician licensure compact is an accelerated path to licensure. It's not the issuance of a license in and of itself, the way it is for nurses. And I'll note that that's not the nurse licensure organization that pursued that compact decided to pursue that type of licensure, and the physician licensure organization that initiated that compact decided to pursue our model. So these are two sort of there are advantages and disadvantages to both models, and the physician groups actually chose to pursue this type, this model. And finally, the last thing I want to mention is that telemedicine really is only doable and relevant and helpful to patients if insurers are required to reimburse and to pay physicians for the work that they do when they're practicing telemedicine. Telemedicine doesn't really save practices money. If anything, it increases the complexity of providing medical care. Now you have two systems to maintain, whereas before you just had the one in-person system. And so we were instrumental in getting a pay parity requirement signed into law in the early days of the pandemic. That requirement has always been a temporary requirement, so each year, essentially, we have had to extend the requirement. Our current requirement will end on December 31st of 2024. And so it's really, I would say, our top immediate priority in the next couple of months to extend that requirement again. We are fighting for a permanent extension, but you can imagine that the insurance lobby is opposed to a permanent extension and is fighting us pretty hard on any extension at all. But that's why we're here, to engage in that type of advocacy. So that's sort of that's telemedicine in 250 years in a nutshell.